philosophy of contract law. These are the sort of words of wisdom that I've developed through my experience over the last now 10-ish years of practicing law, specifically in the transactional space. So first and foremost, and this seems obvious, but it is something that I've learned bears repeating. The agreement itself must serve your client's business model. Just for the sake of clarity, what's a business model? It's how your client makes money. If your agreement, if what you've written up does not serve the business model first, then you're doing it wrong, right? Now, obviously, the other side has a chance to, they have to have it serve their business model as well, and we'll get into that in detail in terms of how you do that. But the first thing you need to think about when you're writing a contract is, okay, what is the business model and how can I structure it in such a way that the business model is ultimately served? Because if there's no business model, there's no work for us, and that's a problem. Next, the best definitions seek to clarify, not confuse. This is, most of these things are things that really should be considered obvious. However, a lot of times, we contract attorneys, we get sort of bogged down in the minutia of things and we don't see the forest for the trees, as it were. And so, this is also really important. When I try to define something, I try to make it as plain, simple as humanly possible, unless that's impossible, in which case I try to make a reference to a definition within the industry. So just as an example, if I'm looking at something like EBITDA, and instead of going through what EBITDA is as just a matter of being completion, I say, EBITDA, or earnings before interest, taxes, depreciation, and amortization, shall have the definition as defined in the generally accepted accounting principles. Boom, easy, fair. You can just go to the reference. But really, the whole idea is to make sure that when you read the definition, you understand what it's trying to accomplish. Next, be mindful of each party's interests and where they diverge. Now, in the world of transactional law, the interests of the parties don't always completely align. And I find that depending on the nature of the deal, it may be helpful to kind of judge them into alignment, depending on how you want to structure the deal. You should be mindful of not just your client's interests, but also the interests of the other side. Because at the end of the day, if you're not able to get a deal done, then there's no business. No business, no work. We're all out of a job. It's a problem. So be mindful of the other side's interest. Try to put yourself in their shoes a little bit, and throw them a bone or two. At least show them that you understand that this is not just you holding up a sword against them, that this is you trying to have a dialogue. That's really important. Contractual language can seek to build or break trust. Now, I could tell you an example of this from my own practice, where recently I was working on a waste-to-energy transaction, and it was a joint venture agreement. And I have been going back and forth with this attorney who is in-house for the other side for about 3-4 weeks. And he came back to me with a new set of red lines, which almost killed the deal by itself. I showed the CEO, I discussed it with them, and then we called the other side's attorney and said, why did you structure it this way? Why did you use this particular language? And they said, well, so I can sue you if I need to sue you. Now, that probably wasn't the best choice of words. Really, in retrospect, he could have said, well, I just want to make sure my client's protected, and that would have been fine. But the fact that he used particular language specifically so that he can bring an action quickly and sort of cut us off at the head, made my client say, you know what, I'm losing trust in this. He ended up going directly to the other side's CEO and said, look, I cannot work with this attorney anymore on your end. He's killing the deal. They ended up switching to another member of their in-house counsel team, and we were able to close the deal as of last week, which was very nice. So again, contractual language can seek to build or break trust. Ultimately, business relationships are all about trust. All of the stuff that we've been doing over the past few hundred years in terms of generating and building on contract law and stare decisis and all that, ultimately it comes down to how much trust do you have versus how much trust you have in the other side versus how much trust you have in the contractual language, right? And even though you can pretty easily argue that trust in the contract language is important for us attorneys, and it very much is. Trust in the other side and doing a deal is more important for the business owner. So you need to be able to balance those two interests.